welcome to another edition of ACLU on the Hill. We're joined by Jason Groth today, who is the Smart Justice Coordinator at the ACLU of Utah. How long have you been doing this job?
So I've been doing this a little bit over a year. I started during the legislative session 2018, and now this is my second session.
And where did you come from before joining the ACLU of Utah?
So I was a public defender kicking around in Colorado. I was in Grand Junction, Colorado. I was a public defender there for 3 years. So I handled cases all the way down to a petty offense, all the way up to homicide.
Wow. Okay. So a lot of criminal justice experience leading into the Campaign for Smart Justice. Could you sum that up in one or two sentences? What is the goal of the Campaign for Smart Justice here in Utah?
Here in Utah, we are working on combating racial disparities in the criminal justice system. Yeah. And we're also working on reducing mass incarceration by 50%.
Those are two challenging goals, and that's definitely a weighty thing to pull. But you've been very active in the legislature this year, testifying on a lot of bills. Let's talk about a couple of them. There's two, in fact, that came up a couple weeks into the legislature. One was about theft amendments, I think enhancing penalties for thefts, and the other was a legal term I wasn't familiar with. It's called Plea and Abeyance. Can you describe what those two bills were like, how you testified on them, and then what actually happened with those two bills?
Yeah, so let's go ahead and take the theft amendments.
That would be first. HB 189, I believe.
Yep, spot on. So with HB 189, the way that bill was set up, it was set up as a sentencing enhancement. So if you had 4 misdemeanor convictions, in the last 10 years, your sentence would be enhanced instead of being a misdemeanor, and this is a theft amount between $100 and $1,500, that would be kicked up to a felony on your fifth conviction. And so that includes enhanced penalties, and that could include prison time up to 5 years.
Wow. So, I mean, this would be sort of even minor shoplifting crimes, right? $100, it's pretty easy to get to $100 with shoplifting. So someone could commit what is technically a misdemeanor and then be punished as if it was a felony.
That's spot on. And when you look at the aggregate cost, so if you take the top dollar amount, so 5 times $1,500, and we think about that number in comparison to what it would cost to house somebody in prison, even for a year, that's $35,000. Wow. And so there seems to be definitely a case of that the punishment doesn't actually fit the crime. And one of the issues here with our testimony, one of the concerns that we raised, and this was echoed by other people testifying as well, is that we do see a lot of these populations that would fall into this category for fifth offense within 10 years that are really targeting people with addiction issues and people that are experiencing chronic homelessness. Like you said, that getting to $100 actually is a lot easier than you'd think. If you, if it would be, let's say, clothing, for example, a jacket, that could easily get you one item that sometimes you might be trying to get because you need that to survive. Also, when we think about addiction issues, some people are using that to really uplift their addiction, their habits, to support those. Maybe uplift isn't the best term, but what that does is it doesn't actually create any way to help those people out. It actually creates barriers for them to receive help.
And puts more people in jail for a longer period of time, and definitely goes against the idea of reducing our jail population. So, wow. Okay, tell us a little bit about, well, what happened with that bill, actually? That was the Theft Amendment Bill, HB 189.
Yeah, there's a lot of discussion about it in committee hearing. It passed out of committee with a favorable recommendation.
Did you testify against it?
Yes.
Okay.
And then it ended up dying on the House floor.
Okay.
So, pretty overwhelmingly so.
Wow. Okay. And there was a companion bill that was similar from the same sponsor. That would have been what we call the Plea and Abeyance Bill. It was HB 293. That bill did something quite similar, but it was more about the procedures that sort of prosecuting attorneys can take. Tell us what Plea and Abeyance is about.
Plea and abeyance, there's other terms for it. It's also commonly known as a deferred judgment. So essentially the way that works is that if somebody's accused of a crime, they can say that they're guilty, admit guilt for the crime, but there's no conviction that enters. And you get what's usually considered a probationary period. So, for example, you could do 1 year of a probationary period if you follow the rules, if you don't break the law, if you go into, for example, some sort of treatment. At the end of that 1 year, when that's done, your case will be dismissed, and then you have the option to expunge the case. And so it's a really good way for prosecutors, especially with people with first offenses, to give them a kind of reconcile the idea of getting a second chance and also being able to prove that you deserve that. It's also a way for somebody who's accused of a crime that is really scared about a jury trial to take a course of action where they have control of the situation to get their case dismissed down the road, whereas jury trials can be scary because you don't have a lot of control over the jury's decision making.
So this sounds like a tool in the prosecutor's toolkit that can be used and appreciated by both the prosecuting side as well as the defense side, right? It's something that has benefits for both.
Definitely. And it's one of those things that when you talk about plea negotiations, it pops up a lot.
Is one reason that prosecutors like it is that it actually avoids going to trial so they can move through cases more quickly?
Yeah, that's one way to think about it, is that it's just an efficiency tool, that this is maybe a crime that doesn't present a lot of community safety issues, that is a sort of crime that the prosecutor isn't necessarily very worried about, especially with this person's background, especially first offenders, or somebody who seems to be in a tough spot. But prosecutors can also use that as a tool to get people help that they need. So we talked about people with addiction issues getting into the criminal justice system. This is a way for people to navigate the criminal justice system, but then at the end of it, not have a record so they can move on.
Now, my memory about this bill, HB 289, was that it actually kept that charge hanging over the individual even after the completion of the plea and abeyance, that in case they messed up again, it would come back and it was as if they had committed that crime and been punished for it. Is that correct?
That's true. And so what this allows the prosecutor to do is that if somebody even completes their plea and abeyance, it gets dismissed, that if there's another criminal charge down the road, they could use that as an enhancement. So you can never actually fully get out of that situation of being in the criminal justice system. So even if you do a really good job, you complete what you need to do, it gets dismissed, it gets expunged, the prosecutor still can go back and say, hey, we're going to hold this over your head. And so when it comes to somebody considering plea options, they may be thinking, I don't know if I want to take a plea in abeyance because it doesn't really meet the ends that it would otherwise, right? That you wouldn't actually have a dismissal and expungement that really means anything, because the criminal justice system is still out there for retribution as opposed to helping people along and kind of get their lives figured out.
You know, I was at the hearing where this bill was introduced and debated, and it was really interesting because you not only had you from the Campaign for Smart Justice, but you actually had prosecutors testing against it as well, an individual from the Salt Lake County District Attorney's Office. So not a very popular bill across the board. What eventually happened to this bill?
It didn't go anywhere. Didn't make it out of committee, and I think it was tabled officially, but just ended up dying in committee.
And it's true, the ACLU does not like enhanced penalties, and you'll see that theme running through these criminal justice bills. It even comes up with the hate crimes legislation that has been discussed. Anytime that you're enhancing a penalty for a specific crime or from past crimes, that's something we just don't want to go there, right? That's definitely kind of violates the criminal justice ideals that we have. Is that correct?
That's true. Whenever you're expanding the criminal code, you really got to ask why you're doing these things and what's the purpose of it. And if it really feels like a lot of times during the legislative session, we're getting more criminal laws just to be punitive or follow along the theory of retribution as opposed to rehabilitation. And that really flies in the face of legislation like the Justice Reinvestment Initiative, where it's really trying to take a good hard look at evidence-based decision-making in the criminal justice system. And with these bills, for example, there was no evidence to back up that this is going to do anything differently except to increase penalties and actually increase costs with no real effect on what these people are going to be doing as far as deterrence goes, or being able to help get people back on their feet.
Well, it's good that at least in these two instances, the legislature didn't pass these enhanced penalty bills. Your testimony and the testimony of others was able to defeat them. Let's move on to another bill, HB 16. This bill had a lot of jokes running around our office, and I'm sure it did at the legislature as well. The Fraudulent Drug Testing Amendments, otherwise known as the Fake P bill, a bill that kind of passed early on in the session. I believe you testified against it. Tell us why the ACLU was against this bill and how it changed, how the bill actually became a little bit better as the process went on.
So the bill actually, I believe, passed out of committee during interim session. So it was already hitting the ground running by the time we got to this year's legislative session.
Pretty much a straight flush, right?
That's true. But fortunately for us, it was a watered-down bill because the original bill had penalties So if you would have possession of fake P, that'd be a Class B misdemeanor.
That's a pretty serious charge, isn't it?
It is, because that's the same classification that you'd have for possession of marijuana illegally. So possession of the fake P is just as bad as possession of illegal drugs here in Utah. And that, that changes a little bit with the legalization of medical marijuana. But there's also penalties like a Class A misdemeanor if you actually distributed this. So if you would sell somebody fake urine, then you could have a penalty that's even worse than if you would possess an illegal substance.
Wow.
And so that was what was kicking around during the interim session, which raised a lot of red flags, because the purported purpose of the bill was to help people struggling with addiction. But it doesn't make a lot of sense that you're going to help people by giving them more penalties, more jail time, and more fines. And that's one of the things that a lot of people don't think about, is that you a lot of times have fines that come along with these cases. You also have mandatory surcharges that'll affect how much it costs too. And in Utah, surcharges are very high, around 90%. And so essentially you're paying double what the fine amount is, based on the type of crime. And for people that are struggling with addiction issues, a lot of times, just anecdotally as a public defender, they're very cash strapped, and that goes to, like I said, our concerns with the theft amendments, right? So interestingly, a lot of these bills have some interplay, there's some dialogue between them.
Yeah.
So with the fake P bill, what eventually happened, and we appreciate Representative Ellison taking on this issue seriously and discussing with other people about the actual effects and ramifications, is that now the penalties that actually went through and passed and are going to be signed into law are going to be infractions.
Okay.
And so you're going to avoid the jail time. There may be some fines associated, but it's not going to be nearly as heavy as it was previously.
Much lower on sort of the scale of punishment.
Yes.
Okay.
And I think it maybe hits more the spirit of trying to help people with these issues, but at the same time trying to address the issue of getting around or skirting urine tests is the purpose of the bill.
Got it. Okay, and that was HB 16. Did pass the legislature, on its way to the governor to be signed. Okay, assuming there's no bathroom break in between. Okay.
Yeah.
One more bill we'll discuss, which fewer jokes and puns. That is HB 415, a bill that came in late in the legislative session, but has actually moved pretty quickly. I believe it's just 1 or 2 steps away from passing and becoming law. It deals with civilian review boards, boards that usually cities set up to monitor a police department or other municipal agencies. Tell us a little bit about that bill and the testimony that you gave on it.
Sure. Just for some quick background on civilian review boards, or oversight boards, I'll call them COBs for short. But COBs have been around the United States for quite some time. There's some as old as being around in the 1930s. They really picked up steam in the 1960s and 70s as they got, there's a lot more community feedback about police oversight. And so a lot of Midwestern cities started creating these community oversight boards, like Chicago, Detroit, Kansas City, and eventually Los Angeles, and other larger cities around the country have started looking at what they can do. And they have a lot of different options as far as how they want to do reviews. They can do reviews of complaints. So if there's an officer complaint, they can review those complaints and see if they're legitimate. Some of those are more of auditing boards to see how well the police department is performing overall. And there's different compositions of the board. Some of the boards are actually elected positions. Some of the requirements for different boards require former law enforcement. Some preclude former law enforcement from being part of the boards. And so depending on what the local community really wants from that board, they can really craft a COB to do what they want it to do.
A lot of individuality, personalization.
And address the issues that are really impacting their board. And so just kind of the brief history here is that there's been different organizations that have been advocating for more robust sort of oversight board in different Utah cities, including here in Salt Lake City. Different organizations like Utah Against Police Brutality, Black Lives Matter, are looking for more police accountability when it comes to a lot of different local issues. And so that was kind of the start of the discussion around what that means to have a COB that's maybe a bit more robust in Utah. And so this bill is a response to that discussion. The bill was ran as a bill to protect police officers and police departments, so that when they were recruiting new law enforcement or new officers, that they wouldn't feel additional pressure from having more community, responsiveness or oversight, and that they won't be intimidated to apply. And also to prevent whatever board, whatever COB exists, I guess, from running amok and just making decisions without due process considerations.
Okay. So it was a bill that would have restricted, how the civilian oversight boards, the power that they have, right? And would have done it statewide and limiting how municipalities could craft these boards to really fit their needs.
Correct. It doesn't prevent a board from existing.
Okay.
And so if you listen to the testimony, you kind of can see that there is maybe some talking around kind of the core issue with this bill. But the main issue with this bill is that it prevents a municipality, so a city government or a county government, from creating a COB that has certain powers, such as the ability to require the COB to review policies before they get approved and are implemented, before budgets are approved and implemented, before somebody gets hired or appointed. And so that those capacities are stripped away from those municipalities from creating a board to do those things. And so it doesn't prevent a board from existing or reviewing those, but it prevents a board from taking independent action on those issues.
Really strips power away that perhaps the municipality or those in charge would want that board to have.
Correct, especially when a board can be really composed of experts in those fields. You see a lot of these boards that are maybe ex-law enforcement or judges or lawyers or impacted communities, and they can take those perspectives and apply them to a policy for a police department, and then maybe have the power to say yay or nay on it, and then kick it back to the drawing board to address some of those issues, especially for impacted communities that maybe don't normally have a voice at the table, but are the most disproportionately affected from law enforcement action.
Now, you testified against this bill, I believe, on 2 occasions. Is that right?
Correct.
In the House and the Senate committee hearings. What arguments did you hear in favor of the bill? Was it the idea that police officers aren't going to take jobs because they worry about this oversight, or that this was just a bill, like you said, that would restrict these committees or these oversight boards from running amok and just causing too much, intervening too much? Was that mostly what was said?
Generally, that's the gist of it,
Yeah.
But it seems to be a solution without a problem, because none of these boards with that type of power actually exist. How those boards are crafted and made up aren't just going to pop up overnight. There's going to be a lot of input and involvement from whatever elected officials are going to be overseeing the creation of it. So you might have a city council creating one for a police department, and for a sheriff's department, you might have the county commissioners overseeing that. And so I think there's definitely arguments that are really outside the realm of what really takes place when these boards are created. And so I think it's kind of a knee-jerk reaction that we don't want something that's violating due process rights that's going to prevent us from doing our job, but not acknowledging at the same time there are mechanisms to make sure that due process does occur. You can actually craft the policy or the purpose of the board while you're creating the board at the same time.
Gotcha. Ultimately, the buck stops with the municipalities or the elected leaders there that set the policies for the board, figure out how they're created. I mean, there is some accountability in place for sure.
Correct. And especially when you think about those agencies creating those policies or creating the board, they are looking at their local issues and their local concerns. And so this bill is the state saying, you can't do that. Even if you want to, even if you have a fair process, even if you give due process considerations to those actions by the board, you can't do it.
So last time we checked, this bill was in the Senate. It had already passed the House. I think it just needed 1 or 2 more votes in the Senate before it would become law. But we're running out of time, right? We just got, about 30, 32 hours left in the session. So do you think this bill could pass?
I think it could. I think that because it doesn't prevent the creation of this type of board, which was one of the main concerns, and that's where the discussion drifted a lot. It's like, well, does this actually prevent the COB from existing? The answer is no, but it prevents one from existing with certain powers. But I feel that most of the discussion, those concerns are alleviated with about COBs actually existing. As long as they can exist, it seems like people are okay. I guess legislators are okay with the idea of limiting those powers and giving the final decision making to the city council or to the county commission.
Got it. So that's HB 415, just sort of on the brink of passing or not as we come down to the final hours of the legislative session. Well, Jason, you've been really busy this year, spreading your smart justice knowledge up at the Hill. We appreciate you coming on ACLU at the Hill to let us know what you've been doing and educating us quite a bit about criminal justice reform. So thank you.
Yeah, it was great speaking to you.
All right, thanks.